said, so you want general law to be passed?
No, Your Lordship.
No. In the sense, wherever there is a debar for the advocates, you must permit. No, that's not. Each case, this is what the delinquent officer or your section head, he could argue that.
The advocate is running into problem because he has reframed the issues according to his convenience. Yes, definitely. That's why the court was very clear to ask whether you have left out anything when you reframe your issues.
No, Your Lordship. Section 30 will be right with that.
Okay. All right.
In the case, there are 3 issues, and you have made it 2 issues. Yeah, you can conclude.
It is humbly submitted that all provisions that debar a lawyer from appearing before decision-making authorities are violative of Article 19(1)(g), Article 21, Article 14, and the principles of natural justice.
It is also submitted that the restriction that has been placed cannot be considered a reasonable restriction under Part 3 of the Constitution, Your Lordship. Therefore, Your Lordship, the right to legal representation must be provided to the parties and the right to practice the advocates in the interest of justice.
Yeah.
The council seeks permission to submit the oral arguments. The Lordship, my issue is whether Section Rule 76 of Sexual Harassment of the Women's Act Workplace Rules 2013 violates the Section 13 of the Advocate Acts or not. So let's get into it with the statement that whatever my counsel stated, it was case-to-case basis on an exceptional matter. It was not a violative. The counsel totally accept that it is not totally violative, but exceptions is always there, and exception should be made. With that, I'll read out the Rule 76, which state that the parties shall not be allowed to bring in any legal practitioners to represent them in their case at any stage of the proceedings before the complainant committee. So, my Lordship, this is a rule. I'll state Section 28 of the Sexual Harassment Act. We state, Act not in derogation of any other law. The provision of this Act shall not be in addition to and not in derogation of the provision of any other laws for the time being enforced. This is the whole matter of Your Lordship that we have to enforce into. That this section also deals with shall, and the rules also deal with shall. My Lordship, this is a general assumption that always the Act will prevail over the rules which is given by the Government of India. So, my Lordship, in Sexual Harassment Act itself, it is given that the other laws, other acts which are there, it should not be derogated. And Section 30, as Your Lordship has already quoted in 2011, has been added as a legal practitioners can practice in any other authorities also. As the last
What is the derogation from any other law? That
Indeed, my Lordship, whether there is a
Which is the section?
28,
28.
Your Lordship.
Yeah. Read it.
Acts not in derogation of any other laws. The provision of this act shall be in addition to and not in derogation of the provision of any other
Which
law.
provisions are derogatory to which law?
Indeed, my Lordship, this is to the humble court that they have to define that which law it is stating, because it is a very blanket restriction and blanket assumption that can be given. My Lordship, we are here for that purpose only. This case has...
So unless you show the derogation,
Indeed,
we
my
can't
Lordship.
apply Section 28.
Indeed, my Lordship, Section 30 of the Advocate Acts says that there are rights in any other authorities. In any other authorities, there is a large ambit. Even the committees, which is ICC, form under the Sexual Harassment Act, come under other authorities, and there should be a legal representation under that also. So, my Lordship, there is a clash, and there should be a harmonious construction between both that.
Either you argue on derogatory clause
Indeed,
or harmonious construction.
My Lordship, I am making an assumption that the...
No. Court will not go on assumptions. Are you submitting your arguments on this non-derogatory clause, or are you pleading for harmonious construction?
My Lordship, there is a clause which is Rule 76 that prohibits. There is another clause which is 28 which says that there should not be derogation. My Lordship, we as a council plead that the court should look into section 28 and allow legal representation in ICC also. That's my whole submission, Your Lordship. I move ahead. I'll go ahead with why the POSH Act was enacted. Because
whether section 38 is in derogation of section 30 of the Advocates
indeed,
Act.
my Lordship, because
That's what you wanted to say.
indeed, my Lordship.
All right, tell that.
How it derogates?
Develop it, that argument. Let us see.
My Lordship, section 30, as it says that Advocate Act says that they have right to represent in any court, tribunals, or any other authorities. Any other authorities also deal with the committees that is formed under section 4 of the POSH Act and section 6 of LCC. So in that, if the legal representation is not been given, then that is a derogation, my Lordship. That's the whole summation. My Lordship, we have to look into the Sexual Harassment Act, that is POSH Act, how it is came into the picture and what all the laws that is there. My Lordship, the POSH Act came from the Vishaka versus Rajasthan case. That was a landmark case. Guideline was given by your Honorable Court that what will be the guideline for the. Then that is Beijing statement came where the human rights summit was happened. After that summit, the whole statement was human rights issue were asked. If you look into the preamble of Sexual Harassment Act, it states, and whereas the protection against sexual harassment and the rights to work with dignity and universal recognition, human rights by international convention and instrument such as Convention on Elimination of All Forms of Discrimination Against Women. So, my Lordship, even the foreign laws were included. So, I will cite foreign laws which are always there. My Lordship, please look into the petitioner's.
Counsel, you are not satisfying us on the derogation, section 28.
My Lordship, only one submission is there on that derogation.
Now go back to 30.
Indeed,
section 30.
Indeed. I'll read out
Surplus 3.
Indeed, my Lordship.
Read it.
Before any other authorities of a person before whom such advocate is by or under any law for the time being in force entitled to practice.
So entitled must be under the law.
Indeed, my Lordship.
So it can't be derogatory when it is not, entitlement is there. How can it be derogatory?
My Lordship,
I can understand if this clause was not there. You have full-fledged rights to argue anywhere. But once this clause is there, and that has been followed, how can it be derogatory?
My Lordship, my co-counsel already deal with the legal representation.
My Lordship or your Lordship?
Your Lordship. Your Lordship.
Your Lordship. But this, you are asking not section 30 and derogatory provisions, you are saying.
That's why, Your Lordship, my co-counsel first deal with why legal representation is required with the articles. And
We have understood that his argument.
with that submission only.
Now you started with section 28.
Indeed.
That
Your
it is
Lordship.
derogatory.
Indeed, Your Lordship.
Show us how it is derogatory on the face of section 30 subclause 3.
Section 30 itself allows.
Allows.
Deviation.
Yeah.
Your
Now, how
Lordship.
can it be derogatory?
Your Lordship, section 30 asks the advocate to represent his client. Represent the client in all
If
the
permissible under any law. Section clause 3. Read clause 3.
Your Lordship, I am reading. Before any other authorities of a person before whom such advocate is by or under any law for the time being is in force entitled.
In force entitled to practice.
Indeed,
So
my Lord.
law must allow you to practice.
Your Lordship, where there is a phase, where there is something that is legally required, where if I read out what is the assumption of Sexual Harassment Act always act with a code of civil procedure. So they have the power to take evidence. They have power to cross-examination. They have the power to go into that whatever WhatsApp message that was there. So Lordship, all this came under the law. All these notions are under the law.
Now we accept that
Indeed.
you are entitled to appear before personally legally authorized.
Indeed.
We accept it. But it goes along with subclause 3. Again, you can't read a section in isolation. You have to read the entire section.
In entirety only I am reading, whereas I am stating that 30 state that lawyers, as we, the fraternity, we have the power to represent. And in another way,
Power, right?
Power, right, everything is there subject to the law permits.
indeed, my Lordship, in section Rule 7.6,
So you have not challenged section 30. I mean, your section of the virus of the section 30.
Class 3.
Class 3. You are not challenged today.
We will not challenge, my lordship. This is our.
Then you are
right.
bound by it.
We are abiding, but in that case only we are saying that where there is a rule that says the section 7(6) state there is a no legal reputation, but 28 also says that there can be no derogation. So that's what we are making a submission that section 30 also implies, because as the act is ultra virus, and that has been stated by my co-counsel in the first statement, that is an ultra virus. So that's why you want to put section 30.
Council, you
Indeed.
have to make submissions. See, it is otherwise because my co-counsel has stated no, it will not become otherwise. You should cite an authority which has declared it to be
Your Lordship, I'll go ahead with
Otherwise, he
the,
has made his submissions. It is for the court to decide whether.
I'll go ahead and case. This is the same case but not the same forum. That has been highlighted. Nandlal Bajaj versus State of Punjab. The advisory board is expected to act in a manner which is just and fair to both the parties. It is arbitrariness of the procedure adopted by the advisory board that the violative of impugned order of detention, while there was no right under the section 11(4) of the Prevention of Black Marketing and Maintenance of Supplies of Essential Commodity Act 1980 or section 8(c) of the Corps Act to legal assistance to the detainee in the proceeding before the advisory board. He is entitled to make such request to the board, and the board is bound to consider such a request while so made.
Because while considering Article 21, that judgment has been laid.
Indeed, my lordship.
Preventive detention.
That is a
For
grave
that,
situation.
that's a different one.
Totally grave situation.
Totally grave situation.
My lordship, here we are talking about POSH Act, Sexual Harassment Act. We as a council totally say that this is also a grave act, which is totally, in a sense, go to the mindset of people. And I'll give example, if my lordship, there are not every person equal in the statehood. Every person's capacity to think, everybody's capacity to act, everybody's capacity to defend itself is not the same. So that's the submission, your lordship, the council want to treat, that there should be a just and fair remedy given to the both the parties, where the council can also protect the right of the people in that position.
Proceed.
Indeed, my lordship. Your lordship, if I give example one more, there are people.
The council argue on facts, argue on law. Don't give examples.
Your lordship,
When we have spare time, we will call you. You can give
indeed, indeed, my lordship. Your lordship. Your lordship, if I go back to my submission of the human rights, that so the PICT Act 2, the court, that is the page number 17, PICT Act 2 for the view of PICT 1, discussing the matter against the ender. By case, the court held that there was no absolute right to legal representation. It was a matter for the discretion of the adjudicator, but the adjudicator cannot lay down an absolute rule against a legal representation he should be willing to permit in an exceptional case. That's the whole submission.
That's the last line, 3 lines. In exceptional case.
There should be a no.
We have not shown this is an
Your
exceptional case.
lordship, there should not be a blanket restriction. That's the whole summation. The whole act talk about a blanket summation, and the blanket is not only derogation of our practice, but also for the client to address themselves. The people need lawyer. Why? Because they want to save themselves. They're not doing any crime in the sense they're not doing after having a lawyer. They'll protect themselves, which the legal representation will protect their rights. That's the whole contention. So maybe I fumble a lot, sorry my lordship. So your lordship, when the legal representation is happening, the lawyer will protect the right of the people who are their client. In this forum where there is blanket restriction, their right are being infringed. Their protection are being infringed. That's the whole contention. This is the first case we are hearing, your lordship. So we, as a petitioner, we want you to look into it. And although case-to-case basis are there, we want the same to be taken care of. That where the mobile was taken by both the party, they have all the security and they can use it. So why not? This is an exceptional case where the evidence can be shared, given from the fact of the case, your lordship.
So
why?
we didn't understand your that mobile. What is that mobile business?
Your lordship, the fact of the case state that the mobile was used by both. Correct. So this is the exceptional case where the fact already
No,
stated.
the party can say that. That's a fact. There is no big rocket science is required like advocate. What happened in mobile? How WhatsApp was sent? What is it? Why your expertise is required?
Whether an advocate can prove that this message is sent by somebody, it has come from this mobile to that mobile.
That's all.
And the rules are there.
Indeed.
If it has come from X, it has come from
That's
X.
all. It's a technical. IT person will tell you.
Indeed.
Not you and me.
Your Lordship, we are not only filing a case against one person. We are taking the assumption of all the person who cannot fight a case against themselves, who are not well versed with the phone. There are people who are not well versed with the phone and they don't know that.
The fact that the phone was attended by somebody else
Indeed.
when it is not in the office or when it is busy, that the complaints committee will take note of.
That's all.
Don't wonder about that.
Indeed, Your Lordship.
Are busy to take note
That
of.
doesn't require any expertise.
Expertise of an advocate. Legal knowledge is not required for that.
Your Lordship, when the evidence are being taking place, where the persons are not educated, there are labors also under which ICC is being placed. ICC is not only for the person who use the mobiles, who have well versed with the laws and knowledge. There are other people who are low grade also. They cannot defend themselves. They don't have the power to even, they don't have the knowledge to talk to other person. So at that point, they need an advocate.
Only because they can't afford. This law has been made. That let them say that whatever you want, inquiry committee will look into it. There are higher forums, they will look into it.
Your Lordship, Your Lordship, that is there. That we totally agree with. But Your Lordship, there should be no blanket restriction. That's the whole contention of the that this law and section 28, if you read out, there is a blanket restriction which the law is against the ultra vires. Your Lordship, if I move ahead,
Yes.
banning advocate from appearing before the court, tribunals, or any decision-making authority.
Indeed, Your Lordship. Your Lordship, the existence of Bar Council of India, which was created by a parliamentary act, Your Lordship. The functions and the powers are conferred by the Parliament through the Advocates Act, Your Lordship. It is not conferred by the Constitution of India. If it were to be so conferred by the Constitution of India.
Then why did you refer to the schedule entry and all that? If it is not under the Constitution of
Your
India.
Lordship, to submit that the Parliament has the power to make laws in the legal profession.
Parliament is constituted by whom?
The Constitution of India, Your Lordship.
What is the submission that you want to be?
Law is not made by constitution unacceptable.
Freedom of profession is there in Constitution itself.
That's all.
And to operationalize what is there in 1901G, all this.
Mother of all laws is the constitution.
Indeed, Your Lordship.
Then constitution has not made the law. What is that?
Your Lordship.
Why you are differentiating between constitutional laws and this Advocates Act as something extraordinary?
Your Lordship, the fact that the was proposed by the Council, Your Lordship, was to prove the autonomy of the legal profession, Your Lordship. With respect to that, it can be regulated by the Parliament's Act, Your Lordship. It does not require a constitutional amendment, Your Lordship. The Parliament has the power to regulate the legal profession, and they don't need to go into the Constitution to amend any of the provisions there in order to regulate the legal profession. The Constitution itself has given them the rights, and they've exercised that particular right to regulate the legal profession. And in that case, they have granted the autonomy.
Is, if the Parliament ventures to regulate this profession, which is an autonomous profession, that will be struck down by the court. Okay? So just because it has created an Advocates Act, it never means that Parliament has liberty to repeal Advocates Act and say, no, now onwards there will be no advocates in this country.
Indeed not, Your Lordship. The Council would beg to differ here and present one.
There is no way you can differ. There is no way you can differ. Because right to be represented by a council is a constitutionally ardent right. Your Parliament cannot touch it.
Indeed, Your Lordship. The submission here is that the Parliament can regulate the legal profession, Your Lordship. Your Lordship, the reasonability of the restriction will be further argued by my co-counsel, Your Lordship. With respect to the privilege of the autonomy and independence that is conferred to the legal profession by the Parliament, Your Lordship. Your Lordship, the Black's Law Dictionary defines privilege.
Privilege is conferred by the respective bar councils. Okay? Bar council decides who should be enrolled. It is not the Parliament.
Your Lordship,
And Parliament has given this power of prescribing who should be enrolled.
Qualification, etc. Everything is under the
Bar council.
Your Lordship, indeed, Your Lordship, with respect to what privilege is a particular or peculiar benefit or an advantage that a particular class of citizens has over the other class of citizens. Your Lordship, if the Council would like to draw the bench attention towards particular
A
sections.
driving license is a privilege. Advocacy is not a privilege. It is a noble profession.
Indeed, Your Lordship, the Council agrees that legal profession is a noble profession, Your Lordship. Your Lordship has argued that the autonomy, the independence that's granted to the legal profession is the privilege, Your Lordship. Legal profession in itself is not a privilege, Your Lordship.
There
It's
is
a
no
noble.
alternative. There is no alternative but to grant autonomy. Otherwise, as a state, you will fail. Because you wanted to be a good state, you have enacted Advocates Act.
Indeed, Your Lordship, that is.
And you have one for hands up. I do not want to touch. You are the learned people. You
If
decide.
autonomy is not there, then every day government will pass one order prohibiting the advocates, everything. Appearing in this court or whatever court.
Indeed,
Isn't it?
Indeed, Your Lordship, the Council is merely trying to place that the Advocates Act has given has established the Bar Councils of India.
Okay.
And that independence in
Madam
autonomy.
Counsel, Section 30 uses a word, right.
Indeed, Your Lordship.
Is it a privilege?
Indeed, not Your Lordship, it's a right. It's a statutory right.
It's a right.
It's a statutory law.
Who said it is a right?
A statute, Your Lordship.
Parliament has.
Indeed, Your Lordship.
You are
Parliament.
representing the state.
Indeed, Your Lordship.
You are in a position to stand because of your enrollment on the roads. Otherwise, you are no ASD. Unless you are there on the roads, you cannot be Solicitor General. And you are pleading against that autonomy of the. Then tomorrow they may say, Madam so and so struck up.
Your Lordship, the Council would beg to differ, Your Lordship. The Council is not trying to place that the autonomy of the legal profession is not in existence, Your Lordship. Your Lordship, it's merely submitted that the Parliament is entitled to make laws. It can regulate it.
Okay.
The autonomy is present.
What next?
Your Lordship, the Council would like to again place in view that the autonomy exists, Your Lordship, and the Council would like to draw the bench attention towards Section 29 of the Act, which recognizes that the advocates are the only class of people who are entitled to practice before the courts of law. And Your Lordship, further, Section 33 also declares that only persons who have been enrolled as an advocate under the state law are entitled to practice. Further, Section 30 also provides that the right of advocates whose name has been entered in the state roll have the rights to practice in front of any courts, tribunals, or any person who is legally authorized to take evidence. Your Lordship, before the enactment of the Advocates Act, there were other people like muktiyars who were allowed to who are allowed to practice law and bring in their observations in front of the honorable bench. Your Lordship. The Advocates Act, when it enacted, granted a monopoly to the legal profession, considering the noble nature of it, Your Lordship, and hence the autonomy that is granted, the monopoly is itself the proof that the autonomy is present, Your Lordship. Your Lordship, a bare reading of these provisions will submit that the statutory right of the right to entitled to only person who are allowed to practice in before the bench or the courts of law is the proof that the independence and autonomy of the bar councils is established, and hence this independence is granted by the Parliament through a parliamentary statute, which is the Advocates Act of 1961. Your Lordship.
Madam Counsel, your point is well taken. Autonomy is necessary, independence is necessary. That's why the petitioners argue that you should not try to regulate that profession. Right? Till now what you have done is perfect. Perfectly in keeping with the dignity of profession, nobility of profession, autonomy of profession. But the moment you venture to regulate, you are spoiling what you have created.
Your Lordship, the Council would like to draw the bench's attention towards the Constitution of India, Article 19, Subclause G, Your Lordships. Here, the Parliament is empowered to make impose any reasonable restriction on any right that is conferred, Your Lordships. Your Lordship, that can be done in the interest of the general public or in order to prescribe any professional or technical qualification necessary to practice any particular profession, trade, or a business, Your Lordships. Your Lordship, every right that has been conferred either by the Parliament or by the Constitution can be curtailed, can be regulated, and can be reasonably restricted to a certain extent, Your Lordships. And a legal profession, considering the impact that it has on the administration or system of justice, it is important for the Parliament to regulate the profession to a certain extent, Your Lordship, which is done reasonably, Your Lordships. Your Lordship, the restriction that is imposed is something that's inbuilt in the enjoyment of right, Your Lordships. No right can exist without a corresponding duty or a corresponding.
If restrictions are to be imposed, they should have been incorporated in the Advocates Act itself. Right? and they are incorporated here also, as the brother judge mentioned in clause 3. And that is to be specifically brought into force under certain of the legislations. And you have done it by excluding lawyers from appearing before complaints committee.
See, one more problem for you.
Indeed, Your Lordship.
If you go to clause 30, subclause 2, we agreed with the council. Before any tribunal or person legally authorized to take evidence.
Indeed, Your Lordship.
Isn't it?
Indeed, Your Lordship.
Now this internal committee has power of civil court. Are you aware?
Indeed, Your Lordship.
Then, if it is a court, why you are preventing an advocate from appearance? That's all is the question. Simple question. Forget about your constitutional obligations. That. Simple question is, if it is an authority taking evidence, then some assistance, legal assistance is necessary. So it comes under the clause 2.
Indeed, Your Lordship.
Then why you are not permitting the advocates under the law? Why we should not struck them that clause?
Your Lordship, it's submitted that the ICC is it's not a judicial body, Your Lordship. It is not passing any judgment, Your Lordship. It merely examines the facts, takes evidence, and if in case there is
for that purpose, it has got civil court's power.
Indeed, Your Lordship.
Then
Your Lordship, the council would like to draw a parallel here, Your Lordship. Your Lordship, when it comes to any normal case, any normal criminal case, the police are entitled to take any evidence, Your Lordship, under section 92 of the CRPC.
we could have understood that, but person with legal knowledge, that's the problem here.
Indeed, Your Lordship, the council would like to again place in record that the ICC does not have the same powers as that the court has, Your Lordship. With respect to any technicalities, Your Lordship, to give an illustration, Your Lordship, if there is a technical evidence in case of the electronic evidences, Your Lordship. Your Lordship, the proceedings of the ICC is not considered as a judicial proceeding, Your Lordship. So there is no the requirement of a certificate under section 65B of the Evidence Act is not required, Your Lordship, merely because it is not a judicial proceeding, Your Lordship. The technicality here is avoided merely for the fact that it does not have judicial power, Your Lordship. They are merely presenting a report that will be further provided to see whether the prima facie case exists. And that is the only function of the ICC, Your Lordship. They are not passing any judgments, Your Lordship. They do not have the power that is conferred to the Honorable Court, Your Lordship. Your Lordship, the council seeks permission to proceed with the further issues.
What further issue?
Now you have to submit, the committee submits a report based on the evidence collected.
Indeed, Your Lordship.
Isn't it?
Indeed, Your Lordship.
Whether it is accepted by higher authorities is different.
Indeed,
But
Your
the
Lordship.
role of the internal committee is to look into the evidence before it and come to some conclusion.
Indeed, Your
So
Lordship.
it is acting like a court.
Your Lordship, it is
Though it is not named as court, but it comes squarely false under 30 part 2, authority recording the evidence. Or what is that? Taking evidence.
Indeed, Your Lordship, they will be taking technical evidences, Your Lordship, but the mere fact that they do not have all
If they are taking evidence, the petitioner's case squarely falls under section 30 part 2.
Your Lordship, the rules with respect to the Evidence Act, Your Lordship, are not applicable here merely because it's not a judicial proceeding, Your Lordship. That is what the
Summary proceedings.
Indeed, Your Lordship, it's a summary proceeding. It's not a judicial proceeding, and hence the technicality of evidence, the point of technicality of evidence, is therefore not valid because of the reason that they do not have the power, exact power of the courts to take the evidence, Your Lordship. Your Lordship, it is not that it is to be proved beyond reasonable doubt that there is an existence of sexual harassment or an existence of non-existence of sexual harassment, Your Lordship. It just has to be factually in the prima facie pre-proved, Your Lordship. That is the requirement under the ICC, Your Lordship.
What is prima facie proof? This is a new standard of proof that we are stumbling upon for the first time.
Prima facie, the council meant to say that in the prima facie, if there is a case that exists, Your Lordship, the council would beg pardon for the slip of tongue, Your Lordship.
preponderance of evidence.
Further, Your Lordship, it's humbly submitted that even the Council agrees that the legal profession is an independent profession, Your Lordship, which is again regulating.
Don't use terms. Independent profession is different. Autonomous profession is different.
Indeed, Your
Global profession is different. Law is all of them.
Indeed, Your Lordship.
Okay, you are arguing on what?
Independence and autonomy.
Okay, come on.
Your Lordship, the legal profession is regulated by an autonomous body, Your Lordship, and the Constitution, by way of Article 19, Clause G, 19 sub Clause 6, and also by way of the schedules list that was presented before the bench, empowers the state to regulate this autonomy in the interest of general public, Your Lordship. With respect to the interest of general public, it will be more elaborately dealt with by my co-counsel, Your Lordship. Your Lordship, the mere existence of Bar Council of India to regulate the legal profession, to make laws, to make any laws, to regulate the technical standards, to give out any etiquettes that has to be followed by the lawyers in front of the honorable bench when they are presenting their cases. The mere existence of Bar Council is a proof that the legal profession can be regulated by the Parliament through its
You are
act.
arguing against yourself.
The bench, Your Lordships. Your Lordships, this is Counsel number 2 appearing on behalf of the respondent, that is Union of India. Counsel will be dealing with issues number 2 and 3 given in the moot proposition. Your Lordships, issue 2 is whether right to appear before any court, tribunal or decision-making authority is a fundamental right of advocates. Your Lordships, it is most humbly submitted that the right to appear before any court, tribunal or decision-making authority is amenable to restrictions that may be imposed by the state, making the right not absolute in nature. Your Lordships, here in the present juncture, the Council would like to completely agree that there is a right given under Article 19 Clause 1 Clause G to practice any profession, trade or occupation. We are not contending that. We are not contending whether there is a right or not. We are also not contending whether state has a right to impose. We are absolutely not dwelling into that. We are only here concerned with the fact that the petitioner's application of what exactly Section 30 of the Advocates Act says. Your Lordships, the question that the petitioners have raised is about the POSH 2013 Act, which was enacted in 2013, well after the notification of Section 30 came into picture. The Internal Complaints Committee.
Going by your submissions?
Your Lordships,
You are going by your submissions or you have improved upon your submissions?
we have improved, the councils have improved upon
You
it.
are taking permission of the court further. Proceed.
Your Lordships, here in this instance, one simple particular question can resolve this dispute about what exactly is the right of the advocate to stand before the Internal Complaints Committee. And that question would be whether the Internal Complaints Committee is a court or a tribunal or a person that is legally authorized to take evidence. And if this particular question is answered, then we would well arrive at the fact or the answer whether the advocates have a right to appear before Internal Complaints Committee. Your Lordships, the answer for this will be provided in the case State Bank of India versus JAR Developers. That is provided in page number 9 of our compendium. Your Lordships, State Bank of India versus JAR Developers was decided in the year 2019 by this Honorable Court. Here what they have exactly held is that the in-house committees that are formed within a particular associations, whether they have the power to make judicial decisions or whether they qualify as tribunals or whether they qualify as persons that are legally authorized to take evidence, and whether that interpretation will match with Section 30 of the Advocates Act. Here the Council would like to place on record that Section 11 of the POSH Act, the committee is given the power to discover documents, and at the end they are not given the authority or they are not given the power to decide on that particular evidence whether the accused is at the wrong or right. It has the power to decide whether the case exists. They have the power to come to a conclusion of an inquiry to see whether a case exists or not whether the accused is right, not whether the complainant is right. That particular
Counsel,
decision.
is this judgment is binding on us?
Your Lordships, is the court referring to
State Bank of
versus,
India.
Which
JAR
court?
Developers?
State Bank of India.
Your Lordships, this decision is
State Bank of India versus Jar Developers.
Indeed, Your
You are
Lordships.
referred to that, no?
Indeed, Your
Yeah.
Lordships.
Is it binding on this bench?
Your Lordships, the Supreme Court has decided this particular case. Your
We are
Lordships.
also Supreme Court. What we have?
Indeed. Your Lordship, the council here
Five
is...
judges who are sitting.
Indeed, Your Lordship.
Isn't it?
Indeed.
We are not advocates here.
Your
We are 5
Lordship.
judges here.
Indeed, Your Lordships. Your Lordships, as per the council's knowledge, the bench consisted of 3 honourable judges, Supreme Court judges. But here we are merely trying to derive the principle that was referred by the bench.
Because you have said that. Is it binding on us? We can give. What is the answer?
Indeed, it is not binding, Your Lordships. It is persuasive in
We can
nature.
consider.
Yeah, you can. The bench can definitely consider, Your Lordships. The council here is merely trying to establish the principle that is referred in that particular case. Your Lordships, now a brief reading of the POSH Act entirely, what is given in section 11, the powers that is conferred to the Internal Complaints Committee, will give a brief as to how exactly the procedure is done. Now when we look into the procedure, what it says is, in simple 5 or 6 points, the council would like to place the procedure to the court. Number 1 is they will take evidence, they will decide whether there exists a prima facie case or not.
The question is, in general, whether advocates have a right to appear before all these courts that are created under the Constitution.
Yeah,
This is not a particular issue.
indeed, Your
Court is not
Lordships.
concerned about.
Basis is this POSH Act.
Indeed, Your
But
Lordships.
according to them, wherever such restrictions are placed,
Indeed, Your
all of
Lordships.
them.
All of
If
them.
you justify that
Indeed,
this
Your
particular
Lordships.
provision in this
Indeed.
act is valid,
Indeed.
the attack on other acts remains.
Indeed, Your
So
Lordship.
that way you will be required to argue 100 and odd.
no, that's what the council said. It is in general.
Indeed, Your
When we
Lordship.
particularly
Indeed.
asked.
Your Lordships, the council has her arguments ready for when it comes to the question of all laws that they have questioned.
Yeah.
They have questioned all laws that are there in place currently. The council will deal with this particular issue. Quickly, the council will wrap up her arguments regarding to section
Okay.
30 of the
Okay.
Advocates Act. Your Lordships, now as I said, in the procedural aspects, they come to a conclusion whether there exists a case or not. They make their report, and if there exists a case, they will merely give recommendations to the employer. They will merely give recommendations to the district officer. That is a
These
district.
recommendations, I tell you, this is not recommendation of a politician.
Indeed.
There is a legally qualified
Indeed.
person.
Indeed, Your
Okay.
Lordships.
National Human Rights Commission also makes recommendations.
Indeed.
Women Commission also makes representation.
Indeed.
State Human Rights Commission also makes. Minority Commission also makes. Recommendation you cannot belittle when qualified people are sitting in the committee.
Indeed.
These
Your Lordships.
recommendations, they are as good as the judgments and they are respected everywhere.
Indeed, Indeed, Your
Okay,
Lordships.
so you cannot belittle that there is nothing. It is only a recommendatory body. No, recommendatory
Indeed.
body is very, because the further process will be based on this recommendation.
Indeed, Your Lordship. Your Lordships, the council has due respect to all the people that are sitting in the bench of the Internal Complaints Committee. The council is not delving into that. Whereas the council here
So
is
you have to
saying,
respect because that is your own
Indeed,
internal complaints
indeed, Your
committee.
Lordship.
State has done this.
Indeed,
It
Your
is
Lordship.
elected by the state.
Your Lordships, here the
Yes, you
question,
cannot escape that.
indeed, Your Lordships, here the question is whether the legal representation can be allowed in a departmental inquiry, an inquiry that is taken by the in-house committee. We are not questioning the composition. Who is sitting in the composition, how the composition formed, we are absolutely not contending that. We are questioning whether right to representation can be allowed in departmental inquiry. Because these cases happen in an association. And the reason why the woman is approaching the ICC and not a domestic court.
See, it can, under section 13, it can recommend what particular actions to be taken.
Indeed, Your Lordship.
It's not just saying that yes, it is proved and bidden with it.
Indeed, Your Lordship.
Based on the evidence collected, it will give the recommendation what is to be done.
Indeed.
And they are very specific.
Indeed, Your Lordship.
Take action for as a misconduct, to
Indeed.
deduct notwithstanding service,
Indeed.
dismiss from the service.
As good as a
etc.
judgment itself.
As good as it's a judgment.
Indeed, Your Lordship.
And only because of that, civil court's power has been given to the internal committee.
Your Lordships, here.
Only for the purpose of working out this, come to the conclusion.
Your Lordships, the council here would like to place on record that the power of the civil code is given very directly given in section 11 of the POSH Act. Section 11 of the POSH Act reads nothing but that Section 11 of the Posh Act reads, Your Lordships, for the purpose.
You are stuck up in that act. Now the very simple question is, this act was enacted in 61.
Indeed, Your Lordships.
In 2011, you had a wonderful Kumbhakarna style of sleeping, right? And you should have continued with that. Why did you enforce it?
Your Lordships.
Having enforced, now you are trying to escape through violence.
Your Lordships, the notification was indeed given in 2011, that is 50 years after the enactment of the Advocates Act. The Council is aware of that. But here, when we talk about the details that are given in Posh Act, the details have to be looked into absolutely, because this will determine whether there can be legal representation or not.
You cannot be a feminist before this court. You are representing the state.
Indeed not, Your Lordships. Your Lordships, the Council here is not representing any party in particular. Our duty is to only represent the state, Your Lordships. Indeed, Your Lordships. Your Lordships, now when it comes to the question about the petitioners questioning all laws in picture, all laws, they have questioned all laws in picture. Now, Your Lordships, let us look into what laws as of current status debar advocates from appearing. As of now, Your Lordships, Section 36 Clause 3 and 36 Clause 4 of the Industrial Disputes Act debar advocates from appearing. Number 1. Number 2, Section 11 Clause 5 of Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act. Number 2. Number 3, Section 17 of Maintenance and Welfare of Parents and Senior Citizens Act. Number 3. Number 4, Section 13 of Family Courts Act 1985. Number 5, Section 8E of the Control of Foreign Exchange Act and now the Posh rules. These are the acts in the present status, in the present laws in force.
Senior citizens you mentioned, there is a judgment of High Court of Karnataka.
Your Lordships,
are you aware of that?
Your Lordships, there is a judgment of the Supreme Court itself, that is KG Suresh versus Union of India, where the law has the provision has been declared unconstitutional. It has already been declared unconstitutional. The Council would like to rely on this particular principle as to why it was declared unconstitutional. Your Lordships, now what the petitioners have failed to inform this honourable bench is that of the validity of all the provisions that bar advocates in these particular acts have already been decided by this honourable court, giving out various principles. For example, Section 13 of Family Courts Act, it was addressed in Lata versus Union of India, where it was held that Section 13 has no absolute bar or prohibitory nature of being represented. There is no complete bar. There is a proviso to Section 13 that is being interpreted differently. These things, these judgments and these pronouncements have to be appreciated by the petitioners, because these are the pronouncement that is given by this honourable court itself, Your Lordships. Now coming to Section 17, as Your Lordship stated, Maintenance and Welfare Act has already been addressed and declared. Section 17 has already been declared as unconstitutional and ultra vires to Article 19 Clause 1 Clause G as well as Section 30 of the Advocates Act.
Madam Counsel, very simple question. Why in these fora that you mentioned, articles are kept out?
Your Lordship, coming into that, now here in the jurisprudence that was given by this Honourable Court when it came to Family Courts Act was that there is a proviso. It is not a complete prohibition, number 1. When it comes to Maintenance and Welfare of Senior Citizens Act, it was given that Maintenance Tribunal is a judicial body. Maintenance Tribunal is a judicial body, therefore they have the power to take decisions and make decisions. So therefore advocates have an absolute right to appear before tribunals. That is given under Section 30 itself. That is why this particular pronouncement was given. Now coming into Section 11 Clause 5 and Section 8 Clause E of Black Marketing Act and the Control of Foreign Exchange, these come under Article 22 Clause 1, Your Lordships, where whether a detainee, that is a person who has been detained by the right authorities, have the power of or have the right to legal representation. This has been decided in the celebrated case of A.K. Roy versus Union of India.
Explaining the provisions. The question is, on what principle lawyers are kept out?
Your Lordships, this is the interpretation of the Council, Your
No,
Lordships.
don't bother about the Council's interpretation. You go to the basics. Why advocates as a class are kept out of certain of the forums?
Your Lordships,
Why they are admitted into certain of the forums? What is the reason?
Your Lordships, why they are kept out of certain forums is because the forum may not be a judicial body. Number 1. Number 2, why they are allowed in many forums is because they are a judicial body. They have the right of representation because that is given given under Article 19 and Section 30, where they have said that in front of court, tribunal and persons where you are
Madam
legally
Counsel,
authorized.
you have to appreciate who is an advocate.
Indeed, Your Lordships.
Okay, who is a professional.
Indeed, Your Lordship.
Okay.
Indeed.
So once you accept that an advocate is a professional,
Indeed.
he has his own professional ethics.
Indeed.
He has his own integrity.
Indeed.
And you should not be scared of an advocate appearing before any forum. And in fact, advocates are to assist in arriving at right decisions.
Indeed, Your Lordship.
They are not there to win the cases for their client. They are there to administer justice, discover truth.
Indeed, Your Lordship.
And in the records, you have an advocate who returned the brief of sitting Prime Minister also.
Indeed, Your Lordship. Indeed.
Okay, that is an advocate. Advocate you cannot beat it. Advocate is an open person.
Counsel, taking your analogy for tribunal, it has been permitted. Next one, again I am coming back. What is your answer?
The
Person legally authorized to take evidence.
Your Lordship, this
It
particular.
is also part of that. Continuation of tribunal.
Indeed, Your Lordship.
Isn't it?
Indeed.
You can appear before any tribunal or person legally authorized to take evidence. So if that what is held not good so far as tribunal is concerned, it would be alta, whereas also so far as this clause is concerned.
Your Lordship, here the legal, like the council has stated, this evidentiary rules is not entirely applicable on the decisions that is taken by the Internal Complaints Committee. Because in Rule 7 Clause 4 of the POSH rules, they have stated, it has been given to us, that they have to conduct the procedure in a manner that it ensures principle of natural justice. And there are several pronouncements by this court where it has held that any action or any crime need not necessarily be proven beyond reasonable doubt. That power that this committee or the decision that the committee is arriving into is an exception to the Indian Evidence Act. Because if a case goes, Your Lordships, the council here would also would get back to the point about the reasonability of the restrictions laid, and also see whether the test of reasonability is been held good in the restrictions imposed, and the council would move to a prayer. This is one last detail that the council would recommend. Your Lordships, now coming to the violation of fundamental rights, to decide whether there is a violation or not, the restriction imposed must pass the test of reasonability. And let us consider one of the most celebrated cases and preferred case for the test of reasonability. It is MRF versus State of Kerala, given in page number 11 of our compendium. Your Lordships, here there are some guidelines that are laid down to see whether a particular restriction passes the test of reasonability and it is not manifestly arbitrary. Number one, Your Lordships, not arbitrary or beyond the interest of general public. Here, Your Lordships, the council would like to state that the restriction imposed is not arbitrary in nature and it is not beyond the interest of general public. Because here the petitioners are representing the bar. They are questioning whether they have the right to represent or
Just
not.
was laid down in V.G. Rao versus Madras. V.G. Rao versus Madras is the case wherein for the first time the Supreme Court said what factors should be taken into consideration to decide whether the restriction is reasonable or not.
Indeed, Your Lordship. Your Lordship, there were,
They are
as
the
per...
fundamental things.
Your Lordship, we have the case with the State of Madras versus V.G. Rao.
Okay, proceed.
The council would proceed with this particular test and justify
Go
the...
with your own latest decision.
Your Lordships, in order to judge the reasonableness, no abstract or general pattern or a fixed principle laid down for universal application. There is no general pattern or there is no absolute pattern for what exactly is reasonable and what exactly is not reasonable.
That's
It
what
is
they have
definitely...
argued. That's what they have argued.
Your Lordships, by arguing this, the council is merely bringing upon some merits to the state, Your Lordships, because this will definitely prove our case. Because if there is a general pattern or if there is an absolute pattern, then all restrictions will be either reasonable or not reasonable based on the guidelines that is given to us. We have to also check whether these pass the test of reasonability or not. Since there is no general or absolute Reasonableness or not, Your Lordships. Since there is no fixed principle pattern or any universal application, the Council here would like to state that the grounds that the petitioners have taken to judge question the reasonableness will not hold good, since there is no universal application as such. And Your Lordships, one more last detail that the Council would like to bring to the Court's attention is the objective of the POSH Act and the direct nexus that is required. There should
What is
be,
the objective?
Your Lordships, the objective of the POSH Act is prevention, protection and redressal of complaints about
Where is
sexual
that?
harassment. Your Lordship, it is given in the Act here. In the Act.
No, objective will not be given in the Act.
Your Lordship, the Council. Your Lordship, the Council would like to read out the statement of objectives, Your Lordships.
Where is that?
Your Lordships, it was.
It
We
is
have
not in
taken
the Act?
the Act. It's not given in the Act, but it is a part of the Act. That is, there is a
No,
objective behind.
It's not the part of the Act.
Your Lordship, there is an objective behind the enactment of a legislation, and here the Act came in at the aftermath of Vishaka was a state of Rajasthan. So based on those principles, there is a statement of objective that has been given by the
The
Parliament
statement
for
of
enactment.
objective can be an aid in the interpretation of the statute.
Itself.
We
Then
have not
any-
come across any rule of interpretation wherein statement of objection reason will be taken into consideration for
Your-
interpreting a provision of the Act.
Your Lordship,
And especially when there is no ambiguity. There is nothing to be interpreted here.
Your Lordships, in order to see, even when it comes to cases of violation of Article 14 or when it comes to right of equality, to see if there is any intelligible differentia or if there is any difference made, then it has to be
What is
ensured that
intelligible differential?
Your Lordship, it has to be ensured that the difference made between one set of people and the other is based on some intelligence, and it has to be made sure it is reasonable in nature.
You mean intelligence for intelligible differential.
Your Lordship, that is not the Council's argument, Your Lordship. Your Lordship, the difference that has to be sought will
What
have to be
difference?
ensured. Your Lordship, this is merely
You are using an expression intelligible differential. Okay, what is this? Elephant?
Indeed not, Your Lordship. Your Lordship, the Council here is merely trying to say, as an example, that even when it comes to cases of right to equality under Article 14, there are two tests that has to be passed.
You are learned council. Council should not use the expressions if you do not know the comport or purport of that.
Your Lordships, the Council merely stated that to give an example of how cases are interpreted when it
Interpreted
comes to the
sometimes
question
not so
of
learned.
Alright, continue.
when it comes to Article 14, that is why the term was used. Your Lordship, the Council here would like to state that the objective of POSH Act, the objective is protection, prevention and redressal of complaints.
Have you got any authority to say that object of the Act can be used for interpreting the provisions of a particular law? Have you got any authority?
Your Lordship, the Council...
We know that it has to be. If there is any ambiguity in the provision, the object of the Act
As a guiding principle,
As a guiding
why
principle.
this law has been made,
Yes.
it is stated in short.
or interpreting
Object of
the
the Act.
provision. Yes.
Object of the Act is stated at the beginning. The purpose why it is made in short. That's all. It is not part and parcel of the Act.
Indeed not.
But while interpreting any provision which says there is any ambiguity, that has to be taken.
We can look into
The
that.
object of the Act has to be taken. into
Your
consideration.
Lordship, the Council here would say that the Council is placing reliance on the pith and substance of the Act.
Yes.
Or what the objective of the legislation was when they were drafting the Act.
Okay.
Or what the pith and substance of the Act is. Now the Council, coming back to the POSH Act, here when it comes to redressal of complaints, the ICC was formed to make sure that objective has been passed. That is, any redressal of complaints, any complaints that has to come by the complainant, that it has to be served through when it comes to the Internal Complaints Committee. Now the objective has already been served. And in order for protection and prevention of such sexual harassment, now when it comes to legal representation, as my co-counsel has stated, there are so many technicalities that come into picture that may divert the ICC's attention to what may not be necessary to see if there is a prima facie case.
Can the object be one-sided?
Your Lordship,
Supposing there is a false allegation is made. Now what is the protection? Can it be one-sided only to protect the interest without the rules of natural justice?
Your
Both
Lord,
sides should be given.
Indeed, Your Lordship.
Yeah, then-
Your Lordship, this particular enactment is a special legislation. The special legislation here, it is cited to one gender particularly because there were certain cases or several judgments or
But at the
several
same time,
instances.
other gender cannot be deprived of rules of natural justice. That's all we are asking.
Indeed, Your Lordships. Your Lordships, here the other party, that is the accused, absolutely has a right to present himself. It is not a case where the complaint is given to the ICC and they decide there is a case. That is not the case. The case is that the complaints will come, the same copy will have to be served to the accused also. He has to present his case. The rules of natural justice is followed. Audi altum partem is absolutely followed in this particular procedure.
Advocates should not talk amongst themselves. You have to closely follow the case because you may be asked to express your opinion sometimes as an amicus curiae.
Your Lordships, the Council would like to proceed with the play.
Yes.
Okay.
Your Lordships, wherefore, in the light of issues raised, arguments advanced and authorities cited, the respondent humbly prays that this honourable court may be pleased to adjudge and declare that the legal profession is not an independent and autonomous body under the Constitution of India, that the law... Autonomous profession under the Constitution of India, that the rights debarring advocates from appearing before any court, tribunal or decision-making authority is not absolute in nature and not unconstitutional, and the laws that debar advocates from appearing before such decision-making authorities is not unconstitutional in nature, and dismiss the petition as may be pleased by the court.
No, any other remedy which the court deals with?
Council.
Yes,
Your Lordship, the Council will place two submissions. The whole facts. If you go to the fact of the case, this state on behalf of the Union of India, it is contended that the legal profession, go to the last line, the validity of the law debarring advocate from appearing before the decision-making authority
You are directing the court to go to the last line.
Your Lordship, I am stating in the facts is state the same. The decision-making authority are to be ascertained on a case-to-case basis, and there cannot be a blanket restriction. They already have stated that, and they have not even raised that issue in this whole submission. That's totally unacceptable. The second is,
that's against you.
yes, Your Lordship, we have contended that the case-to-case should be, argued.
No, your case is wherever there is a restriction removed.
Your Lordship, even that the exceptions
This
there.
is what we are asking right from the beginning.
Your Lordship, in the second submission, we have also said that exceptional cases will be there. The human rights, whichever countries have followed the human rights legislation, there are exceptions, and this should always be an exception. Your Lordship, the second contention is that the inquiry report that they have talked, the report itself is not a judgment. But Your Lordship, section 13.2, which talks that where the internal committee of the local committee, as the case may be, arrived to a conclusion that the allegation against the respondent has not been proved, it shall recommend to the employer and the district officer that no action is required to be taken. My Lordship, itself is a decision. If you go to the section 4 of the same section, the employer or the district officer shall act upon the recommendation within the 60 days of its receipt by him. My Lordship, this is a decision. They have come to a conclusion and they are giving the judgment to that. But although it is said as a report, but they are following the same, that is a judgment. It was honored to
The Council would like to answer those questions in a span of 1 minute, Your Lordship. Lordship, the Council won't take more than 1 minute of this honorable court just to answer this particular question. Your Lordship, coming to section 11 clause 3 of the particular act, 13 clause 3 of the particular act that they have referred to, here the petitioners have not entirely seen that to further, they have not read that it shall recommend to basis what question they have raised, that Your Lordships, the councils have represented their arguments on regard to why exactly this won't qualify to be a judicial body, and we would leave this to the discretion of the court to decide on the same basis, Your Lordships. The council has said this.
Reserved.
Stop,